Hi guys, thank you so much for stopping by Bar Talk with Ola once again. Today we want to talk about the writ of Habeas Corpus. The writ of Habeas Corpus. Habeas Corpus is a phrase that comes from two Latin words, habeas and corpus. Habeas is from the root verb have, to have. So that's why you have nemo dat quod non habet, habis. So it's a conjugation of the verb have, to have. And then corpus is from body. Remember when they say corpus Christi, the body of Christ. So corpus or esprit de corps, so corpus, that's where corpus, body, that's where it comes from. So if you join the two together, you have the body. You have the body. So it's a prerogative writ, an administrative remedy that is used to mandate the production of a body in court. So it's essentially, the court is saying that when you apply for the writ and it's granted, the court is essentially saying that bring this person to court, bring this person before us. We want to see this person that you have detained, bring them before us, So that's what we want to talk about in this video. Please come along. William Blackstone has described the writ of habeas corpus as a great and efficacious writ in all manner of illegal confinement. So like I said, it means you have the body. Essentially, when someone has been detained by an administrative authority, an application can be made to the court asking the court to issue the order that is habeas corpus, to command the authority holding that person in detention to produce them in court. So it's a common law remedy that is used to address arbitrary arrest and detention. So essentially, the court is saying that come and show us or tell us why you have held this person in custody. Justify the detention or have them released. So that is what habeas corpus is. The why, this writ is used to protect the right to personal liberty. So it goes to the root of our fundamental rights. So it's a very, very important writ. It is used to defend the encroachment, to defend, one's personal liberty, or to protect or enforce the right to personal liberty. It's a constitutional right, so that's how important this writ is. Essentially, it directs a judicial inquiry into the legality of anyone's detention. So when someone has been detained, this writ will lift the veil to see if the detention is legal, that is, the authority that detained them, do they have power to do such? Has this person been detained beyond the constitutionally provided period of detention? And what is this person being detained for, to inquire into the legality of the detention. That's the why. Now the who. The writ of habeas corpus can be applied for by anyone that's being held in detention. Of course, they can go through their legal practitioner. So it is applied to court, to ask the court to command the production of such person, from custody. It could also be to produce someone to come before the court to testify, and even where the person has died, the writ of habeas corpus can still lie to command the detaining authority to produce the body. Yes. So it's a sword and a shield. It's a sword in the sense that it can be used to challenge the validity of a detention order or an extradition order, or it could be also used to command the release of a detainee. So as a shield, it protects the right to personal liberty in both ways, either to challenge the validity of the detention order or authority, or to command and compel the release of such person from custody. It's not to be mistaken with an application for bail. It is different. If someone has been lawfully detained, you cannot also bring the writ of habeas corpus. This only applies to unlawful detention, or where the legality is not certain yet, to inquire into it and ascertain the legality of such detention. Between 1993 and 1995 in Nigeria, the right to apply, for the writ of habeas corpus was suspended by a decree, the decree number 14. So it was suspended, and as such, prisoners that were detained by the government with respect to state security could not apply for this writ, because the decree essentially suspended that constitutional right. So it suspended that lawful provision for them to inquire into their detention and, ask the court to compel or command their release. But now that is no longer in place. Nigeria is now a democratic society, even though arbitrary detentions continue. Essentially, this writ is used to challenge the validity of an order, an administrative order of detention, and not to vacate a lawful order of detention. If someone has been sentenced, for instance, and imprisoned lawfully by a court order, you cannot bring habeas corpus to release them. So that's essentially what habeas corpus is. Remember, I said that we're going to talk about different prerogative orders. We talked about mandamus. We're also going to talk about certiorari and several others. So the writ of habeas corpus is just one of those remedies, very, very important common law remedies, applicable as administrative remedies. You can look up the case of Ishugbayi Eleko and the officer administering the government of Nigeria, to understand this writ better. In that case, the king of Lagos at that time, Oba Eleko Ishugbayi, he was at war with the British government. There were so many things going on. If you read it, it's an interesting case. So he continually, demanded his release when he was held in detention through this writ of habeas corpus. So he continually applied for the writ of habeas corpus, and when one court would deny him, he would apply again. Another court would deny him, he would apply again. So the court held that this writ can be taken out in different courts, but of course you cannot abuse court process in applying for this writ. But the fact that a judge has denied this writ when an initial application was made does not preclude a detainee from making a fresh application before a different court. So that's all I want to talk to you about. Look it up, read more about it, and leave me comments in the comment section. Don't forget that if you have a personal challenge that you need tailored advisory towards, book a paid consultation. Don't leave your personal details in the comment section. And by all means, don't send me an epistle when you have not booked a consultation slot, because we have a law firm that we run and there's processes to be followed. And if you have not engaged our services as your personal lawyer, it is even illegal for us to provide legal consultation to you, so that we do not put ourselves in trouble. I will see you in my very next video. To-dos.